in everyone across the globe. As the South African government was chosen the act in accordance with our constitutional values and our international law obligations. We have chosen to be on the side of the global majority that has rejected these horrific actions. Our case was rejected in some quarters as populist, blood-libel, meritless, and baseless. Today, as we meet here, there is a growing body of consensus on whether what all we are witnessing is indeed consistent with the statements of the Israel leaders. As Archbishop Makgoba made the following observation in a Times Live opinion piece dated 4 September 2025, and I quote, "In April 2024, Dr. Tlaleng Mofokeng, the South African medical doctor serving as the UN Special Rapporteur on the right to health, warned the Human Rights Council that the health system in Gaza had been completely obliterated and that the right to health had been disseminated at every level. By October 2024, she had introduced a new term for what she was witnessing, Medi-Decide, the use of military force and state police to systematically destroy access to medical care. In June 2025, she declared that the right to health in Gaza had become virtually non-existent. Two Israel organizations, B'Tselem and Physicians of Human Rights Israel, have now produced reports that independently affirm Mofokeng's findings." Close quote. Honorable members, I also wish to remind you that Vonglo Casey, acting on behalf of the South African government at the ICJ, told the court the following, and I quote, "We have heard expressions of outrage that anyone could accuse Israel of acting in this way. We have heard sober assurances that Israel was doing and will do everything in its power to avoid civilian deaths as it exercises its claimed right of self-defense. We have heard boast that Israel's army is the most moral army in history. We have heard flat denials that there is famine in Gaza. For months, people, particularly in the West, have appeared unwilling to accept that accusations are true. How could people look like us and sound like us possibly engage in anything like genocide?" Close quote. The answer we offered to the court as part of pleadings by Ambassador to The Hague, Ambassador Vusma Donsela, was the following. These questions stems from a form of amnesia and denial by former colonial powers in relation to the crimes associated with colonial violence perpetrated against indigenous peoples. These include the denial of genocide. This denial is clearly at play in Palestine. Close quote. This denial of the genocide and the atrocities by Israel and the tacit condemnation of these acts have led to the questioning. Do some believe that Palestinians' lives matter less than others? By extension, it begs the question whether the ideologies of superiority that justify colonial conquest, occupations, and genocide in Africa and other parts of the world still determine which people are deserving of protection by international human rights law and international legal framework. We reiterate that the international community cannot proclaim the importance of international law, including respect of the UN Charter in some situations and not in others. International legal mechanisms are not only to be used to target African and those in the global south. These are universal instruments aimed at the justice for all. South Africa instituted proceedings before the International Court of Justice to preserve the existence of the Palestinian people as a group, to end all acts of apartheid and genocide against the Palestinian people. As highlighted by the President in his State of the Nation address, South Africa acted in accordance with its international obligations by instituting the proceedings against Israel. The case will continue until the court makes a finding. We need to give the court and this case a life of its own. The potential outcome could resonate far beyond Israel and Palestine. In other words, inactions insofar as the conflict is concerned has direct impact on how international law and humanitarian law is applied across the globe in all conflicts that affect humanity. South Africa will continue to act within its institutions of global governance to protect the rights including the fundamental rights to life of Palestinians in Gaza and of all people in conflict areas, in Sudan, in South Sudan, in the DRC, or in any part of the world where there are conflicts. The UN Charter remains sacrosanct. We have also joined initiatives such as the Hague Group, which was established to protect and uphold international obligations to end the illegal Israel occupation and to support the realization of the inalienable rights of the Palestinian people, including the self-determination and to independence in a sovereign state of the Palestinian. We recently co-chaired a meeting of the group with Colombia in Bogota, where 30 countries participated. The establishment of the Hague Group and the recent meeting of the Madrid Group seeks the same outcome: to stop the bloodshed, an immediate ceasefire, and negotiation towards a just peace. In conclusion, Chair, let me stress that South Africa will continue to strive for the primacy of international law, promote accountability, and ensure a just peace. We will also continue to call for two states, the state of Palestine and the state of Israel, to coexist side by side in peace and security. As we have said to the UN General Assembly recently, all obstacles to the two-state solution should be removed, and this includes the immediate ceasefire and commitment to a peace process, the release of hostages by Hamas and political prisoners by the state of Israel, the halting of illegal Israel settlement expansion, the removal of the illegal separation wall cutting across the occupying Palestinian territory, and the resumption of all international reputable humanitarian relief efforts and the reconstruction of Gaza, which of course can only take place once there is peace. Let me also take this opportunity to express our condolences to the victims of the terrorist attacks in Jerusalem. I now, Honorable Chair, with your guidance, whether I should now give the Director General to provide the full details in terms of the case, or I must proceed with the G20, or we can deal with it when we open for the G20. So should I give the DG? Thank you. I now, with your permission, Honorable Chair, request the Director General to provide the full details on the legal proceedings for the meeting. Thank you, Chairperson.
Does the DG have a mic? Can you provide the DG with the mic? Honorable Swart. That's fine, Honorable Swart. Mr. Squela, please move yourself there. TG, how much time do you think we are going to take? TG? So is 30 minutes enough? Okay. So the solution is to do what, Mr. Esquela, Committee Secretary? But can it be flighted there? They can't. Okay. That's fine. Teacher, can you provide him with a mic? Mr. Swart is going to be 30 minutes. Yes, 30. Just only 30 minutes, Mr. Swart. Thank you. Thank you. Chair, you can take over your meeting. DG, are you ready?
Thank you, Chair. We're just loading the presentation on the system and then we can begin. Thank you.
Chair is called an executive briefing.
Okay, thank you, Chair, and honorable chairs from both portfolio committees, Minister, honorable members. So I'll try to be.
But that mic is very low. Take
try
this
to
one
be-
of mine. That one is very low.
Thank you, chairs, and apologies for the slow start. We always know that the efficiency of the committee would have had the presentation for us. So the minister, in his overview, covered a lot of the ground, so we can then give just some overview. As the minister said, Israel declared a state of war following the attacks by Hamas on Israel on the 7th of October. And as the minister has indicated, both in our application to the ICJ and also to the International Criminal Court, we condemn all attacks on civilians, and we had also, in our application, thought that this should be covered as a war crime as well. South Africa and 5 others approached the International Criminal Court on the events of October 7th, as well as what followed. And often, I think, chairs, this gets lost in the media space. So, South Africa argued that following the conduct by Israel after October 7th amounted to a violation of the Convention on the Prevention and Punishment of the Crime of Genocide. I'm just going to call it Genocide Convention from now on so that we can ease with the many words that comes across us. I'm just choosing the slides. So part of the reason we took what is called a contentious, it's not on the slide, which is a contentious approach, is the Genocide Convention doesn't just dealing with justice and accountability after genocides have been committed. One of the main premises of the Genocide Convention is prevention. We took a route that sought to prevent further harm to Palestinians. And that's why we took the route that we did, because it allowed us to ask for provisional orders. And these provisional orders are binding. And we asked for provisional orders on 3 occasions: in January 2024, March 2024, and in May 2024. As early as January 2024, we noted that if the current scale of attacks continued, that the humanitarian conditions would give rise to famine. And therefore we asked for specific provisional orders around the unhindered access to humanitarian aid then already. I'm going to go to a slide that just gives you a sense on the motivation for instituting proceedings. So at the time of instituting the proceedings, remember December 2023, at that point there was about 21,000 Palestinians in Gaza already killed. That number has since trebled and stands over 63,000. But these numbers are likely much higher. And I'm not going to go into the details of that, but there's studies by the Lancet and others that predict that once the dust settles and the rubble is removed, that the projections could come close to approximately 300,000. At the point when we instituted the application, entire multi-generational families were already wiped out, and that is just increased. At that stage, you had over 355,000 homes, which was then 60% of Gaza's housing stock, damaged, or destroyed. At the stage of going to the court in the very first instance, 1.9 million Palestinians, which is 85% of the total population, was already internally displaced or forced to live in makeshift tents in camps with no water, sanitation, or other facilities. Members will recall also what we then call in the course the fiction of what is a safe space and what is not a safe space. Israel bombed, shelled, and besieged Gaza's hospitals. The minister brought to the fore in his opening remarks some of the comments and findings by one of the special rapporteurs, which is South African, on the right to health, on Gaza's hospitals, and it's bringing the entire healthcare system to collapse. At that point already, we predicted that the prevalence of contagious and epidemic diseases that was rife was going to get worse. And we also then, in our asks at the Court for Provisional Orders, stated that the entire Gaza was at risk of famine. So this was the motivation for instituting proceedings. It is essentially about the preventative component of the Genocide Convention. Our objective was to ensure that we don't only punish the acts of genocide as is required by all signatories to the Genocide Convention, but we are equally obligated to prevent a genocide. And that's why we went for what is called the contentious approach that we did. Aside from the facts that we were witnessing, there's also South Africa's history. We did witness in our own time crimes against humanity, including the crime of apartheid, which is now also a suppression crime under international law. And that's our history and our values that made South Africa go to the court for what we saw was, in the words of many genocide scholars at that point, a textbook case of genocide that was unfolding. So since we've gone to the court in December 2023, famine has now been confirmed in Gaza. We, immediately after we did our oral pleadings in January, we cited the very same authorities that have now called it a famine. And at that point, they were talking about stage 3, and they predicted that if things do not change, you will have a famine, and that famine and diseases that accompany famine would in time outstrip the deaths due to military action. So now we have the entire population facing acute food insecurity. We have severe fuel shortages that's crippling water production, and we've also spoken about the fact that at the same time that you're having military campaigns, that you're having famine, you're also having the health sector decimated. So injuries and deaths will then multiply. Insufficient aid is reaching Gaza, which is a clear violation of the provisional orders, which are binding. It's not advisory. It's not optional. It is binding. Israel's response was to launch the Gaza Humanitarian Foundation, which, in the words of many experts on this, including Alex de Waal, is one of the world's most renowned experts on this, has called it the militarization of the distribution of aid, and has been described as a cog in the ongoing genocidal activities. Our petition to the court is confidential, and we've submitted our documentation, which is part of the merits of the case. So we can't share that with the portfolio committee, but what we have done is we've developed 3 dossiers of evidence that is publicly available, and we've provided that to the United Nations Security Council. We've also submitted a 3rd dossier to the United Nations Security Council. We've got numbers, UN security numbers for 2 of the documents. We are awaiting the 3rd document's number because it was submitted in the last 2 weeks. But this publicly available evidence indicates some of the issues that the ministers pointed out, the genocidal acts, but also the intent. And the last dossier focuses a lot on how we got to a point where you have famine, and that famine and the humanitarian crisis is not a side effect of war, that it was the intention. The actual humanitarian crisis was the intention of the military actions. and the attacks on housing, hospitals, infrastructure. Okay. So I think the dossiers we have circulated to members, I know they are lengthy, but I think it's important for South African parliamentarians to read and engage with it. So on the legal principles, I've talked about our petition, which is called a memorial. I won't go into that. One of the lacunas in international law is enforcement. I've said the provisional orders are binding. What we've been struggling is who enforces the binding nature of these orders. The Security Council should do it. They have not done it. What we are trying to do is to use available mechanisms in international law to make the world and the institutions of global governance more accountable to these binding orders. Perhaps my colleague can talk about, Zahir Laher can talk more about that in the question and answers, because we're taking two routes, one to the Security Council, but also using the rules of the court themselves to make sure that they use the powers that they have to enforce these orders. Just briefly, we've got many states that have sought to intervene in the case. 13 states have already filed interventions, and a few more states have indicated their intention to do that, the most recent of that being Brazil. I've spoken about the enforcement of provisional orders, and perhaps Zahir Laher next to me can talk about just the details of Article 94 and Article 11 of the Internal Judicial Practice Resolution of the Court. I think these mechanisms are important for members to understand because the enforcement issue is critical. You want to do that now? No, then increasing conclusions of genocide. The Minister in his overview gave a very comprehensive list, including the report from the UN Special Rapporteur on the situation in Palestine, which was entitled Anatomy of a Genocide. The esteemed Professor William Shabas, who is one of the world's leading international experts on genocide, has stated that the ICJ case is arguably the strongest case of genocide ever brought before the court. Genocide is difficult to prove because of the issue of special intent. Special intent has to be present. Otherwise, it would be a war crime or a crime against humanity. But the special intent component is the important one. I'm not going to go through that. I think the Minister has outlined all the various lists of organizations that have now come to the same conclusions that we have in as early as December 2023. At this stage, I'd like to just, because it's important, the issue of special intent, give my colleague Romy Bremer an opportunity just to talk about some of the issues of special intent that's in our dossier. Obviously, we can't mention those that's in the memorial itself. The memorial is confidential, but in the dossier, which is publicly available, she can mention that. So I'm going to hand over to Romy very briefly.
Thank you very much, and good morning, honourable members. Thank you for this opportunity to address you. As DG Dango has just indicated, we submitted 3 dossiers to the United Nations Security Council, the third of which focuses on starvation. I've tried to pull out a few examples that's contained in that third dossier, which I will try and highlight now. I've tried to reduce it. There's just far too many to mention, so I've tried to keep it to just a few. The important thing is to look at the statements coupled with the actual conduct, and then a clear intention to commit genocide is revealed. So Professor Alex de Waal, who's a leading expert in starvation and famine, and has worked in the field of famine and humanitarian action for more than 40 years, has stated that today, precisely designed mass starvation of the population is happening in Gaza. The Integrated Food Security Phase Classification, or the IPC, has warned that the worst case scenario of famine is currently playing out in the Gaza Strip. De Waal has also stated that all evidence points to a horrifying reality that the enclave has crossed the tipping point into a period of accelerating mass starvation mortality and societal devastation. Time has run out. The Office of the High Commissioner for Human Rights stated on the 3rd of June that Palestinians have been presented the grimmest of choices: die from starvation or risk being killed while trying to access the meager food that is being made available through Israel's militarized humanitarian assistance mechanism. There is an explicit intent to destroy the existence of a group by killing them and subjecting them to intolerable conditions of life, or forcibly removing that group with no prospect of return, or killing and starving them under the pretense that such removal is in fact an option. Starvation functions both as an endpoint where death occurs from starvation and as the process of stripping the people of the vital resources they need to survive, thus leading to a destruction of the people. In 2024, the International Court of Justice found that there was a real and imminent risk of irreparable prejudice to the rights of Palestinians in Gaza under the Genocide Convention. The court issued binding orders on Israel. Israel continues to ignore these orders. In terms of the genocidal intention, Israel's Minister of Finance and Minister in the Ministry of Defense explained the allowance of some aid into Gaza as follows: only the smallest amount of aid will be allowed entry in the coming days. Civilians in Gaza will receive a plate of food and a pita bread. That's it. On 7 July 2025, Defense Minister Katz affirmed the emigration plan and conveyed plans for the concentration and confinement of over 600,000 Palestinians in camps in Rafah. Such transfer plans and their implementation accompanied the Prime Minister's statements and a cabinet decision on the full conquest of Gaza. The Prime Minister said, "We are moving away from raids as a method and towards the conquest of ongoing occupation of territory. Israel's conquest and forced displacement policies come in the wake of its total destruction of Gaza. Some 92% of Gaza's housing units destroyed, and Israeli officials arming gangs to, after killing, maiming, and starvation, further shatter Gaza's social fabric." The Prime Minister stated on 11 May, "We are demolishing more and more houses. They have nowhere to return to. The only sensible outcome will be the desire of Gazans to immigrate out of the Strip. Our main problem is the receiving countries." The Minister of Finance and Minister in the Ministry of Defense stated on 19 May, "We occupy, purge the area, and stay until Hamas is destroyed. Along the way, we are destroying everything that is still left in the Strip. We are dismantling Gaza and leaving it as a smoking ruin, a total destruction never seen before in the world. And the world isn't stopping us." The intent to destroy Palestinians is moreover not limited to Palestinians in Gaza. The Minister of Finance stated, "We must demolish terrorism nests in Judea and Samaria, just as we are demolishing Rafah, Khan Yunis, and Gaza." These statements all occur in the context of an overall genocidal policy, affirmed repeatedly through further statements by Israeli officials evidencing their genocidal intent. On 26 May, the Prime Minister stated, "A war of good against evil. First and foremost, a determined war that is being fought on the battlefield. It is being fought against human animals, against monsters." Sorry. Switch it off. Is it still working? Sorry. "Who attacked us with appalling cruelty 20 months ago, and we will defeat them and wipe them out. They will not remain." Deputy Minister of the Knesset, Nissim Vaturi, stated in a post on 23 February, "Who's innocent in Gaza? People went out and slaughtered people in cold blood. We should separate women and children and kill the adults in Gaza. We are too considerate. No one in this world wants Gaza's civilians. Everyone is pushing them on Israel. They know these are scumbags and subhuman." Further stating, "We will soon turn Jenin into Gaza as well." I think we all remember Rwanda very clearly, and these statements are very reminiscent of the genocidal statements that were made during the genocide in Rwanda. In 1948, the drafters of the Genocide Convention declared that the very purpose of the convention was to make what was simply optional for states into an imperative international obligation. The imperative international obligation to prevent genocide, which is binding on all states under customary international law. It does not depend on the International Court of Justice or the Security Council. It arises at the instant that a state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it the means to have a deterrent effect on those suspected of preparing genocide or reasonably suspected of harboring specific intent, it is under a duty to make such use of these means as the circumstances permit. And I think that's what South Africa is doing. As parties to the ICJ statute, states cannot remain inactive, let alone participate in the willful disregard of the court's binding orders. The most recent order of 24 May 2024 reaffirmed the previous two orders, and it directed that these be immediately and effectively implemented. It did not limit this direction to the state of Israel. All states, and in particular parties to the Genocide Convention, which includes South Africa, must take all necessary and effective measures to prevent the genocide unfolding against the Palestinian people. Thank you very much.
Thank you, Chairs. Ms. Bremer went into a little more detail, but this is just a snippet. In the memorial, you'll find a lot more of these genocidal statements linked to genocidal actions. And it's important that we bring that to the attention of the committee. Part of one of these statements, and we can go to the next slide, attempts to erode international law. To preface this, what we're seeing is institutionalized impunity. When a senior minister in the government of Israel can say the world is not stopping us, that's not an understatement. The world is not stopping the breaches of international law and breaches of the convention, the Genocide Convention, which is incumbent on all of us who are signatories to prevent or to stop. And instead of holding them accountable, what we're seeing is an attempt to erode the institutions to hold Israel accountable. So we're seeing sanctions, for example, on the prosecutor of the International Criminal Court and judges of the International Criminal Court. It's a lot more difficult to do these sanctions on the ICJ because the ICJ is not a statute-based, treaty-based institution. It actually is rooted in the UN Charter, and the US and others are signatories to the Charter, so are in fact signatories and part of the ICJ court itself, so they can't opt out of that. But we do see a clear attack on those seeking to hold Israel accountable through the institutions of global governance, through the legal institutions set up to hold all of us to account. And if this is allowed to happen, we can see a race to the bottom where impunity is not going to be located in one region of the world only. It will be a lot more widespread because people are starting to question. I spoke about the lacuna. People are starting to question if there is no enforcement, if there's willful disregard, what is going to stop others from doing the same? So this is a critically important issue for the committee to engage with. I'm going to end there, and I want to thank the chairs. I wanted Zahir just to amplify in maybe 2 minutes, just the approaches that we're thinking of doing to ensure enforcement does take place.
That's
Thank you.
1 minute, not 2.
Thank
It's
you,
one.
Director
It's
General.
one.
I'll be very brief on this. Essentially, thank you, honorable members, and thank you to the chairpersons for allowing us this opportunity. Essentially, the challenge with international law is enforcement and implementation of international law. Unlike domestic law, where we have domestic institutions that allow us to rely on these mechanisms to ensure implementation, international law has this as one of its most significant challenges. However, in the context of the ICJ, there are mechanisms in place. These often have not been used effectively. But the UN Charter, which of course is, as the DJ has said, is the basis of the creation of the ICJ. The International Court of Justice is a United Nations court. It's not like the ICC, which is a treaty-based mechanism that was created through the Rome Statute. The ICJ is a principal organ of the UN. It is essentially grounded in the UN Charter. The statute of the ICJ is a statute that has been signed by all UN member states when they joined the organization. Article 94 of the UN Charter, essentially Article 94.1, provides that all member states of the organization are bound to decisions of the court. Essentially, that's an obligation you take on when you sign the UN Charter. You join the international system, you join the UN. Article 94.2 provides for the Security Council to ensure implementation of the decisions of the ICJ. Of course, this has not happened, and this is often the challenge with decisions of the ICJ. There are other mechanisms that we're also looking at in terms of how do we ensure implementation, because the court has made determinations. It has issued on 3 different occasions thus far in the South Africa versus Israel matter provisional measures. So the court has given judgments, and the challenge has been the implementation of those judgments. There's another mechanism that has also the court has looked at, and we're looking to see how this can be activated. That is a mechanism in terms of Article 11 of a resolution of the court in terms of its practice, where the court creates an ad hoc committee of the judges to look at implementation of its own decisions, essentially to ensure that there's a credibility of the court and its decisions. So these are the kind of mechanisms we are looking at. Of course, the court being an international forum cannot escape the challenges of geopolitical reality, and therein lies the challenges we have. But ultimately, for us to ensure that there is accountability and implementation of international law, it's important that these mechanisms that are there in terms of the UN Charter are basically abided by. Thank you.
Thank you very much, Minister. Thank you very much, DG and the team. I hope that Honorable Smith will not accuse you of sweeping remarks. It's on a lighter note, Honorable Smith. I think the report is quite clear. Let's give members to interact with the report and give a direction. Honorable Mhlongo, Honorable Mhlala, Honorable Klopa, Honorable Smith, Honorable Chetty, Honorable Member, Honorable Kumbaca, Honorable Member, Mfundisi, you don't want to take. Let's give Honorable Swart, Honorable Mutawong, Honorable Sotetsi. Muela, you'll be the last one. Honorable Mhlongo, is there mic there? It's 3 minutes, 3 minutes. In 3 minutes, you must conclude even the special intent.
Thank you, Co-Chairperson. You can't do that. In this committee, we have not seen the minister for the past 6 months. He has never been in this committee. So we must have this opportunity to engage with him, because we don't know when will be the next opportunity.
That's why he's coughing. He's been hiding there in Gaza.
Yeah, so it's fine. Chairperson, let us ventilate all the issues we want on this matter. First and foremost, Minister, let's go back to the correct and give correct timelines on this matter. You will remember that during the 6th Parliament, on the 16th of November, the EFF submitted a motion to cut all diplomatic ties with the genocidal Israel, and that motion was debated on the 16th of November, and on the 21st of November 2023, the motion received a overwhelming majority support of 248 members of Parliament who voted in favor of that motion of the EFF, and just a measly 91 members from unprogressive political parties voted against that motion. Those members, some of them are in your cabinet in the GNU, from Democratic Alliance and IFP, voted against that motion. They wanted the continuation of the genocide to persist in Gaza. Now, let us also check that and remind the House that the motion of EFF seeked, amongst others, one, to condemn the killing of defenseless women and children in Gaza, including the bombing of hospitals, and that we called upon on all freedom-loving people of the world to support the Palestinian campaign to take back their land in all of its manifestation. And then we called on government to close the Israeli embassy in South Africa until ceasefire is agreed to by Israel, and that Israel commit to binding United Nations facilitated negotiations whose outcome must be sustainable and lasting peace. Now, what came as a surprise to us as the EFF is that to this day, almost 2 years later, the president and the executive have failed to implement this resolution to cut all diplomatic ties with the genocidal Israel. The Israeli embassy in the city of Tshwane is still in operation, run by the Church Defense, and the Trade and Economic Office of Israel is still operating in the city of Johannesburg. That, Minister, we don't take it lightly. It looks like then the government is speaking in folk tongues in addressing the issue of our solidarity as a country to the people of Palestine. Another matter, Minister, wanted to raise is that on the 20th of March this year, the spokesperson of government indicated in a media statement, in a media briefing that was held, that the city of, we learned with shock that they are deploying new minister in Derko to intervene in the city of Johannesburg in trying to stop them from renaming Sentin Drive into Leila Khalid Street. Minister, we don't take kindly to that because it's the first time we hear of such matter happening. We wanted to find out from you because we've since sent the written question to yourself and that remains unanswered to this day. That is it a norm that DERCO gets directly involved in renaming of streets, and we are told by the US that if we rename Sentin Drive to Leila Khalid Street, they are going to move their offices in Sentin and they're going to have problems with us because we are directly attacking their friend, which is Israel. Now back to the matter of South Africa versus Israel at ICJ, Minister. Just yesterday, Israel continued their aggression even in Qatar. Saying they are hunting Hamas leaders that were in Qatar to do the negotiations. And now this is a clear indication that the genocidal Israel is not backing down from this genocide they are committing in Palestine. And I think it is important, Minister, in our presentation that we look at the language we use. Language is very important in addressing matters. This is not a war between two equal states. Palestine has been besieged by Israel. It is not a war between two equal states. It is clear it is a genocide. So we must refrain in our documents for saying that there is a war between Israel and Palestine. Palestinians have been besieged and they've got nowhere to go. They are pushed out of their land. Hospitals, institutions of higher learning, schools have been bombed, and shelters where refugees, Palestinian refugees, run to. They've also been bombed and destroyed. Palestinians have nowhere to go to. They are fleeing into Jordan. They are fleeing into neighboring countries because of what is happening. Now, if you look in the Middle East, the crisis in Middle East, all of them emanate from Israel. It is the genocidal Israel that is bombing Yemen, Iran, Syria, Lebanon, all these countries in the Middle East. If you check, all their crisis is coming because of Israel wants to always attack, wants to play big brother over other countries and supervise. And in fact, they are undermining their sovereignty as a state. Now, the provincial measures that were ordered by ICJ continue to be ignored by the Israeli government. And as you can tell from that warlord, Benjamin Netanyahu, he's got no regard for human life. And if you can look at the conduct of members of parliament also from Israel, you look at their conduct at all internet platforms, whether it's the IPU, they come with the same attitude and the same agenda. They have got no regard for human life in Palestine. They want to wipe the Palestinian people off the surface of the earth. There's no humanitarian aid that is able to reach Palestine. Either it is being stopped or it's denied end altogether, that there must not be anybody who assists the people of Palestine while they are being besieged. And at all times we speak only about Gaza, Chair. I think it is important we highlight that even in the West Bank, people are being killed on a daily basis. Palestinians are forced to flee and go into in the east of Jerusalem. Now we must continue, Chair. We must never get tired to call for justice for the people of Palestine on the genocide that is perpetuated by Israel. Minister, it was very saddening this year during the Comrades Marathon to see former Israeli soldiers participating in the Comrades Marathon. And when we raised that measure with the Minister of Sport, Arts and Culture, he arrogantly says to us that there's nothing we can do. He can't stop Israeli soldiers from coming into South Africa. That brings us to that matter that we must cut all diplomatic ties and we must impose, we must speak to the Minister of Home Affairs as well, that we must impose stringent visa requirements for people of Israel and deny them visas anytime anyone from Israel applies to have a visa to come and visit our country, whether on business or whatever visa. We must deny that visa. We can't have a relationship with Israel. And the continuation of our mines to continue to export our coal to Israel is problematic, Minister. I want to know what is the stance on TERCO on that matter, on the continuation of trade agreements, exporting of goods, of South African goods, especially coal, going to Israel, and the continuation of South Africa to continue to export products and services from Israel, while we have said that the state of Israel is committing genocide and we don't want to have a relationship with them. Because by continuing trade with Israel, it is an indication, Minister, that we are indirectly funding Israel to continue to kill the people of Palestine. So those are and maybe lastly, Chair, is the issue of we must really appreciate the work that was done by Dr. Tlaleng Mofokeng, the UN Special Rapporteur on the right to healthcare. Now her report has been affirmed by other independent UN commissions. And just this morning, Chair, 7 Palestinians were killed in Gaza in the early hours of this morning. So it's a clear indication that we must continue this fight, and Minister, we must make sure that there's always funds to continue our case at ICJ and do follow-ups to ensure that we really get all peace-loving nations to support the people of Palestine. And in order for us to support the people of Palestine in practical terms, it means all countries must cut any diplomatic ties and relations that they have with Israel. Israel must be isolated. There must be economic embargoes that are imposed, economic sanctions that are imposed on Israel. No one must trade with Israel as long as they continue to perpetuate the genocide in Palestine. So we must lobby the rest of the world. We must lobby the AU. We must lobby SADC. We must lobby the rest of the world to impose economic embargoes on Israel, to isolate Israel, and no one must have an interaction with Israel until there is peace and stability in Palestine, and that the people of Palestine are given a right, as it was affirmed in 2004, that they've got a right to self-determination. So that must never be undermined. I see the co-chair wants to stop me. Chair,
Thank you very much.
Eh?
You said that was your last point, and I'm saying thank you very much.
It was the second last point.
You are left with
we
2
haven't
seconds.
seen Minister for more than 6 months. So when he's here, we must ventilate all these issues that we have been raising in his absentia. And it is important that we affirm the 2004 ICJ affirmation that said that Palestinian people have a right to self-determination. And also, going forward, Minister, it is important that we look at the Independent Commission of Inquiry on the occupied Palestinian territory, including East Jerusalem, on the factual findings that indicate there's been attacks and interference with also education in Gaza between 7 October into now 2025. There's been over 405 schools that have been bombed and destroyed in Gaza. And 62% of the buildings that are used for shelter have directly been hit in Gaza, leaving thousands and millions of people displaced and homeless. Over 2 million population of Gaza is in danger of being wiped off of the face of the earth, Chairperson. So I think we must intensify our fight, but we can't intensify, Chair, as long as South Africa still continues to have diplomatic ties with Israel while we are fighting them at the ICJ. We are speaking in folk tongue. It is about time we walk the talk and talk the talk. Thank you very much.
Honorable Swart.
Similar amount of time when we respond, Chair. Please. No, you manage that. Thank you.
Honorable Mhlala is covered. Honorable Mhlala. No, wait. Let's not indict on that. We are going to manage it. Honorable Mhlala is covered.
No, thanks so much, Chairperson. You can't do that to me. So, the Minister and members of the Portfolio Committee from the two Portfolio Committee, International Relations and Justice and Constitutional Development, together with the department, members of the department officials that are here. My colleague here have covered me and she has spoken a mouthful. So the EFF affirms its unwavering support for the principled stand South Africa has taken against Israel at the International Court of Justice. This case is not simply about legal arguments. It is about confronting genocide, settler colonialism, and the deliberate weaponization of starvation against the Palestinian people. South Africa, born from the ashes of apartheid, cannot afford to be neutral in the face of injustice. To stand aside would be to betray our own history and dishonor the sacrifices of those who fought for our freedom. But while we commend the government for instituting these proceedings, we must also hold it accountable. The fight against genocide cannot be reduced to lofty statement and symbolic gesture. It must be grounded in political will, foreign policy consistency, and concrete strategy that mobilize international solidarity and force accountability. So we noted with agreement the Minister's observation in his opening remarks that even as the crime of genocide unfolds in Gaza, the West remain in outright denial. This denial is not just shameful, it is a blatant act of complicity in mass murder. The same West that claims to be the guardian of human rights is the one arming, financing, and protecting apartheid Israel. Their hypocrisy runs deeper here at home when they openly court and collaborate with certain political parties in South Africa, even traveling as organized delegations to Western capital without the consent or knowledge of this country. These parties has become nothing more than the local agents of Western imperialism. It is precisely because of this dangerous alliance between Western powers and their proxies inside our borders that South Africa's independent and moral leadership on the global stage is more urgent than ever. So the EFF recognized South Africa's reliance on the Genocide Convention as both a moral and legal instrument to confront apartheid Israel. This is historic. It affirms that our foreign policy must always be on the side of the oppressed. But let us be clear, symbolism alone is not enough. South Africa must waver under international pressure, not dilute its position to appease powerful state. Instead, we must deepen solidarity with progressive governments, movement, and people across the country who stand firmly with Palestine. So we also acknowledge the department's presentation that South Africa's case came in terms of prevention, one of the core mandates of the Genocide Convention. This is important because it highlights that South Africa is acting not after the fact, but to stop an unfolding genocide. However, prevention without enforcement risks becoming a hollow gesture, especially when the international system itself admits a lacuna in enforcement. It is precisely this gap that South Africa must help close. So, Chair, on enforcement, Israel has openly and consistently defied the ICJ provisional measures. It has escalated its campaign of destruction and starvation, mocking international law, yet our government reports to this parliament remain largely descriptive, telling us about Israel has done wrong, but not what concrete steps South Africa has taken to enforce compliance. This is unacceptable. Mere reporting is not accountability. We must know what specific action has been initiated under Article 94, subsection 2 of the UN Charter to force Israel to comply. And you have also mentioned Article 11 as a sort of ad hoc committee that deals with implementation processes on the side of the judges. So the other question is, why has South Africa not pursued sanctions or economic pressure through the AU and BRICS? Another one is, what is the government's plan if Israel continues to ignore the court's order? Chairperson, this is where the admitted lacuna in enforcement must be confronted. If international laws lack teeth, then South Africa's role cannot end with prevention. It must be about mobilizing the AU, BRICS, and the Global South to plug this gap with political, economic, and diplomatic enforcement. Otherwise, the West will continue its denial while Israel continues to kill our people. So, Chairperson, point number 2 is on the cost and resources. Over 95 million has already been allocated to this case. The EFF made it clear justice has no price tag, and we support this expenditure. But transparency must accompany principle. South African cannot be misled into believing that domestic needs are sacrificed for foreign struggle. So we demand the following answer. Which international partners have been approached to co-found this case, and what results have been achieved? When will the government table a detailed breakdown of the 95.5 million spent and the projections of 2025 and 2026? Is government prepared to launch a solidarity fund that mobilizes international civil society, trade unions, and progressive governments to share the fiscal burden? And point number 3, Chairperson, is on foreign policy consistency. There's a glaring contradiction in South African's foreign policy. On one hand, we denounce genocide in Gaza. On the other hand, we maintain trade, diplomatic, and in some cases, military intelligence relations with Israel and its allies. This is hypocrisy that weakens our case before the world. How does South Africa justify maintaining diplomatic relations with Israel when accusing it of genocide? Why has the government not expelled the Israel ambassador or cut ties entirely? We said we're going to close the Israel embassy. We did not do that. What is the reason? Why are we delaying when the people of Palestine are suffering, they are dying every day while we are watching? And how is South Africa using the G20 presidency to prevent Israel's genocide from being sanitized or downplayed, given the influence of Western powers in that forum? So in overall, Chairperson, legal proceedings are necessary but painfully slow. Meanwhile, Palestinians continue to die daily. The struggle cannot be confined to the courtroom. South Africa must lead on multiple fronts: diplomatic, continental, and grassroots. Beyond litigations, what steps is South Africa taking to strengthen solidarity network with Palestine at the grassroots and continental level? How will the government ensure that the ICJ process does not drag on for years while Gaza is reduced to rubble? And lastly, Chairperson, will South Africa mobilize the AU to adopt a collective stance in support of this case and to confront Israel ongoing defiance? Chairperson, in closing, the EFF insists that solidarity with Palestine cannot remain symbolic. It must be enforced through law, funded with transparency, expressed through consistent foreign policy, and amplified through continental and global action. Anything less is betrayal. South Africa must be remembered not as a state that filed papers, but a state that led the world in the fight against genocide. Thank you.
Honorable Klopper.
Thank you very much, Chair. Good day, Minister, co-chairs, and thank you for the presentation. Chairperson, in 2023, the South African government claims it met with representatives of Israel government. However, I have it that they met with the Jewish Board of Deputies, not the government of Israel. So the question is, who did you meet with? How do you use the Board of the Jewish Deputies, which represent the Jewish community in South Africa, as a springboard to launch a case against Israel? Chairperson, the following questions that I ask are based on the backdrop of the extreme conditions that South Africans face daily. Minister, a year ago you stated that the International Court of Justice would not cost South Africa in terms of legal costs. It has now cost the taxpayer 95.5 million, and further allocations are likely. It is this kind of statement that has misled public perception, allowing for a perception that it would not cost as much as it has. I would need to differ extremely strongly with my colleague to my left, saying that justice does not have a price tag. What are the true projected costs going forward? And I answer specifically, considering the challenges that South Africa as a country is facing due to not having funds, not having the correct price tag. At this time, South Africa, when prosecutors cannot be hired because of a moratorium on recruiting, when there's no training programs for new prosecutors, when recording devices in our courts are broken, delaying justice, when magistrates cannot even access law reports because of self-imposed price tags, when court sittings are cancelled because of basic failure of security and the compliance by the atrocities, when children are still drowning and dying in pit toilets due to collapsing infrastructure, when South Africans go weak without water, how does the government justify spending millions in international court cases instead of addressing the justice crisis as well as the social crisis of the needs of 68 million South Africans? Considering 87 murders per day, which is around 32,000 per year in the country, which is not at war. Something that South African government is failing to curb by its own admission due to a lack of funds and a self-imposed price tag. Where exactly has the money then come from to fund this case? I ask, as the justice system is collapsing under budget starvation. All this is happening while South Africans finds itself on the FATF list, also known as your grey listing, because of our own inability to tackle organized crime, money laundering, trans-border crime, and human trafficking, amongst many others. Why has the International Court of Justice then given Israel 6 additional months to file its counter memorial? If you could please explain this unprecedented action for the additional time. Is it possible because South Africans have these documents circulating to anybody who seems to want them, while it was meant strictly for the Security Council? Chairperson, will further allocations be requested in 2025 and 2026? And if so, how much additional taxpayers' money will be diverted from collapsing domestic services to fund this case? Chairperson, and lastly, what oversight mechanisms will ensure that the expenditure on the ICJ case is reported transparently and in detail to Parliament, so that South Africans can see how every rand of their money is being spent while they are facing an imminent challenge? Thank you, Chairperson.
Honourable Smith. No, leave those things of Honourable Mhlongo spoke about the Sentin Drive, which is not part of the agenda, but I think it's important that to clarify it, Minister. Honourable Glover spoke about water and other issues. Can proceed to Honourable Smith.
Thank you, Honourable Chair. I firstly would like to thank the DG and his team for coming to present to us. I think that the information was certainly very useful and enlightening. Is deeply, deeply problematic. A statement has just been released by the DIRCO minister, and I have it on my phone, and I will read from it verbatim. Thank you for providing the Department of International Relations and Cooperation the opportunity to brief you today on the legal proceedings at the International Court of Justice in the South Africa versus Israel matter, and also South Africa's readiness to host the G20. As per the guidance of the committee, I will deal with the matters to the extent possible. Well, Chair, we've only just sat. What guidance has been recorded by the minister if we haven't even concluded the meeting? And to what extent is this committee just a tick box for the minister and for this department if you can preemptively predict what you think is going to come out of this committee or the engagements? It is deeply, deeply problematic that the executive treats the legislature in this manner. that you think that you can put communiques out like that with impunity?
Honorable
What's the
Smith,
point of us sitting here?
can you provide us with where did you get the statement?
It was released on the DIRCO press group, the DIRCO WhatsApp press group. Statement by Minister Ronald Lamola, Minister of International Relations.
Okay.
Wednesday, 10 September 2025.
Okay.
And Chair, I would call that you please look into the separation.
No, that's fine.
of
They are going
government
to
here,
put, they are going to
please,
respond on
please,
it.
please.
Sure.
I'm not sitting here for my health, if this is how the executive is going to treat the legislature. Chair, I think we need to be aware of the role of this committee in terms of the Constitution. And while I appreciate the discussion around the ICJ case, this room is not the International Court of Justice, and we are not international court justices. It's not our role to discuss the merits of the ICJ case. And I say that because we're a country that believes in the separation of powers. And we as the DA believe in the rule of law, and we respect the rule of law, the rule of domestic law and international law. And in that spirit, I don't think that it's appropriate for us to sit and discuss the merits of the ICJ case. We are neither elected by the people of Palestine nor Israel. We are elected by the people of South Africa to represent their interests. And that leads me to the point that I want to make, which is, what is the cost of the ICJ case for South Africa? Because it does come with a cost for the people of this country as a foreign policy decision. It comes with a financial cost that my colleague, the Honorable Kloppers, has mentioned. There's money that has to come from budgets. We've just come out of 3 separate tablings of the national budget where we have had proposals to raise VAT to plug a fiscal gap. We've eventually had to make sweeping cuts and reforms to the national budget just to make sure that we can fund our own programs in South Africa, let alone international litigation. So there is a financial cost. There is an economic cost. What have we inflicted upon the people of South Africa in the greater international trade system and in terms of the greater international political economy? And how are South Africans paying the price for this going forward? And thirdly, there's a reputational cost. And South Africa has a very grey reputation, let's say, on the international stage. Our country has a history of a very, very and deeply inconsistent relationship with the international legal system and our application and interpretation of the international legal framework. And I would like to draw this committee back to when the ANC governed South Africa with a majority in 2016, where there was a very serious proposal from the National Working Committee to withdraw from the Rome Statute in its entirety, which thankfully was declared unconstitutional by the High Court in 2017. So we are very grateful that at least our institutions uphold our allegiance to the international legal order. But we've had a very inconsistent interpretation and application of international court orders henceforth. Omar al-Bashir is a famous example, flew through South Africa in June 2015. We refused to arrest him. He was within the country for over a week. We continue to meet with Vladimir Putin, the president of the Russian Federation, despite having an ICC arrest warrant against his name for child trafficking. So how do we expect to be taken seriously as a state on the international stage if we ourselves are hypocritical in the application of international law and the interpretation of the judgments made by the very same legal system that we now want to depend on to uphold the rule of law? And I'm not saying this as a personal opinion. I'm stating our own history with these institutions and how we intend on restoring the confidence among our peers internationally if we have such a fragile and inconsistent and unstable relationship with the international legal framework. And Chair, that really is something that South Africa must take seriously, because the law is only as effective as it is consistent. We know that as South Africans deeply. If there's inconsistent application of the law, then who else is supposed to be held accountable? The same thing applies in the international space. Chair, I want to speak a little bit about the economic cost of the ICJ case. And again, without getting into the merits of the case, that is for the ICJ to determine. But taking a foreign policy decision of this magnitude does not come without consequences. And South Africa, as an emerging market and a developing country, cannot take such large foreign policy decisions with impunity or without there being blowback or consequences. We've seen that South Africa is now at the mercy of a tariff war that's been waged against many countries by the United States of America under the Trump administration. One of the reasons is the ICJ case. And the consequence is ordinary South Africans losing their jobs, companies closing down, the threat of hundreds of billions of rands in automotive and agricultural exports to our second largest trading partner. And I would like to understand, as a foreign policy decision, how the ICJ's case was in South Africa's national interest. Because yes, you can motivate that there may be a moral imperative for South Africa to take that case up. But is it in the national interest for us to do so? What are South Africans paying? What is the price that they are paying for this case? And we really need to look. I heard the DG Dango mention that this case aligns with South Africa's foreign policy. Well, I will disagree. If we look at the consequences of this case without discussing the merits, it's not in South Africa's national interest to be pursuing these sorts of foreign policy decisions. And it's not an act of diplomacy, it's an act of litigation, of international litigation. And in the vacuum of diplomacy, I think South Africans are rightly asking what other mechanisms were available to us outside of just launching a case at the ICJ. How are we calling for dialogue if we've removed our ambassador? We can't talk in this dispute if we don't have a voice. The other, I think, failure of South Africa is that our unique political history, having transitioned from a country on the brink of civil war to a democracy, is a strength that we should be using in our foreign policy toolkit. We have a unique strategic advantage in the peacekeeping space that we should have, I think, looked at something around that matter first before pursuing international litigation. And I'm not saying that what's happening in the Middle East is exactly the same as what happened in South Africa. I don't think you can make a direct equivalence. But there is certainly a role that South Africa can play in a meaningful way in international diplomacy without going straight to the ICJ.